What were the court's findings about the changed documents?
Well, I'm going to quote directly from what I got off the internet. On paragraph 237 of our case, Mr. Balabar accepted that the changes made to these documents required initialing by the Bartles and that changing the documents in this way did not comply with the operation manual. That has to be addressed, and it hasn't been addressed. Had that been addressed, we wouldn't have had to go any further, because we did not have a democratic right to initial the pages, which we wouldn't have agreed to. More importantly, they processed that loan without our permission and gave us a loan of $639,000 for which we are apparently responsible, which we're not. We didn't apply for that. By law, we had a democratic right to agree to that change, and it was not given to us.
Mr. Randerson said that he was satisfied that the alterations were immaterial and most were made for the innocent purpose of correcting errors. He says they were not intended to and did not deceive anyone, which means that surely GE should have seen all these application forms, all had errors in the same spot saying they were retired. All the pensioners must have made the same errors in the same place. And to say you're retired when you are retired, that's not an error. And in number 233, it says the first finance application form signed by the Bartles on the 23rd of June 2006 and addressed to EML described their occupation as retired and contained accurate details of their income. So they did know what our real occupation was and our income. In respect of 2007 documents a year later, attention was focused on the finance application signed by the Bartles on the 26th of June 2007 and submitted to EML. As noted above, someone had inserted in their own handwriting a description of the Bartles as self-employed investors and had entered in respect of the period employed the words 12 months.
Yeah.
Twinking, and we said that she said that there was no evidence of twinking, but twinking would have removed the word retired. And we wrote our true occupation retired on the form.
Why do you think you lost the case?
We lost in the High Court against GE because the judge did not believe that Tasman Mortgages Limited, who altered the papers, were an agent of GE. But when Blue Chip collapsed, the PLA notices that were sent out to people saying that if they couldn't find the loan, their houses would be taken from them, was signed by Tasman Mortgages Limited on behalf of GE. So they must have been an agent of GE. We also have on our document that TML, Tasman Mortgages Limited,
We're the lender.
were the lender. And that is written in by somebody other than ourselves. On the 13th of December this year, just after the Supreme Court findings came out, we received a letter from GE letting us know that we'd lost and how overwhelming it must be for us. And it was signed on the bottom by this man, Hamish Blank, Head of Collections, Tasman Mortgages Limited. But the letterhead was GE. So they've suddenly appeared after being in liquidation, and they are working as an agent for GE.
And that was the reason why we lost the first case, because the judge believed they weren't an agent for GE. Now they prove they have, and they are. And in point of fact, in their own application, they said they were the lender as well.
What about your lawyer, Mr. Matthias?
We did win against our lawyer in the High Court because he was very negligent and didn't tell us the truth, didn't tell us about the loans, and there were many things he could have told us, but he didn't bother. Although we had plenty of fraud in our papers, the judge glossed over these and nothing more was said. It was not addressed at all.
We'll take a short break now, And in Chapter 3, Bruce and Judy will tell us about the Appeal Court and Supreme Court hearings.